here
wearing
because
purple and green.
for the last 2 years, this has been our team. And we've done team huddles when Patrice and I have not been on the road. It has been a joy and a delight to further engage with the two of you. And Patrice is now off to greener pastures with her new fancy name badge. And this is our last time that we're presenting together as engagement colleagues. But this woman right here has kept this well-oiled machine running when we've been on the road, when we've been trying to get some of the things done that we'll talk about in this presentation. We're so proud of her. She represents, with all of the other young people in this room, the future of this association. And so we wanted her to introduce us because she matters. Thank you. Okay, hot topics in drug testing. Do you want the clicker or do you want me to have it?
You can have it.
All right.
Can you guys hear me yet?
All right, no.
We can hear me now.
We can hear you now.
Okay.
Okay, are you sure?
Yep.
I don't think so.
All right. Now.
There she is.
All right. We usually start this off with our mission and vision. But one of the things, I won't go through all of that right now, just to say we beat town hall to death this week. But I do want you to remember we are member-owned and member-driven. The only way we can continue to stay that way is if you are involved. And many of you have caught me in the halls in the elevator and said, I want to get involved, I want to get involved. I've said, email me. We are going to ask you to join committees. We're going to ask you to be on the study halls and the town halls and the places where we have conversations so you can be known and your voice can be heard. Come to Advocacy Day, but we really want to see you involved, and that's how you drive your organization, is by getting in on the conversation. So we want you all to do that. All right, Patrice, I'm going to let you start with this first slide.
Thank you. I'd be delighted. And Jennifer Lancaster covered some of this. So I'm just going to tell you that Department of Health and Human Services and DOT were ready for this from a drug testing perspective. Things are obviously moving forward slowly, but we hope steadily. DOT needs to have 2 certified laboratories, as Jennifer mentioned, and all of us have to wait until both laboratories are certified. And HHS has not certified any labs yet, but Jennifer showed you where in the Federal Register, as well as on the ODAPSI webpage, you can go to see what's certified. As far as the oral fluid testing regulation itself goes, so all of the DOT agencies would allow oral fluid testing in concept. We made those changes in the final rule, and so the modes are ready to go too. However, oral fluid testing does not and will not apply to the Federal Railroad Administration's post-accident program. And for those of you who attended the DOT panels yesterday, you heard my colleague from DOT. Look at me, I'm doing it again. I retired on Monday. I guess technically we're not still colleagues at DOT, but she's from DOT. Patty Sun described in great detail the history on why FRA does not fall under Part 40 whatsoever for post-accident testing. So that's not the point of today, but if you were there yesterday, you're in the know. So if HHS certified laboratories are only outside the US, or to the extent that there are certified laboratories outside the US, FAA cannot use those. So I won't go deep into the FAA regulations, but just be aware. FAA allows its regulated people to only use US certified labs, or labs in the US. Next, okay. In its 2019 final rule, the Department of Health and Human Services said oral fluid testing is as reliable as urine testing. In evaluating the progress of science of oral fluid testing and its scientific viability, HHS also looked at its forensic defensibility in workplace testing. We have some great language to support you in the HHS final rule allowing oral fluid testing. And when I say we, DOT wrote that language and gave it to them at HHS because we knew you would need it someday if you were ever challenged in litigation on oral fluid testing in the future. There's language in the HHS preamble that is, your lawyers would thank us. It's geared to protect you, as well as some of that's carried over into the Part 40 preamble to the final rule that was issued in May of 2023. So again, if anything were to happen in the future, you've got backing saying the reliability of oral fluid testing is there.
And one of the things that I want to say about that, I mean, while this is a bullet point on a slide and you go, oh, boys, that's cool. We really have heard over and over and over again, especially through 2023, but even now it still crops up. But is oral fluid is good? Does it have the same science? Is it really as good as urine? Are the test results as reliable? Well, I read something that there were problems with it, and this and that, the other thing. If you're reading that there were problems, that's stuff from like 30 years ago. I mean, we overcame some difficulties in oral fluid many years ago, and it would have never made it through this process were it not as reliable. So when you see that very first bullet point that says, HHS said that it is as reliable as urine, that matters. That means something. We can take that to the bank for reliable test results, and the data backs that up. So we want you to, I just wanted to like highlight that. That is a big deal. Now, we really need you all to understand, and we saw in the slides with current consulting group's annual survey, that about, what was it, somewhere in the neighborhood of 51%? Was it 51% of people said that they understood that they needed to update their client policies or were updating them? What that means is we still have a lot of work to do. I mean, that means there's still millions of people who have not, or businesses that have not updated their policies. You really should not be allowing your clients, to the best of your ability, to perform oral fluid testing if it's not part of their policy. And this is a very hot topic because we really do believe that some employers don't even really fully grasp all the way that policies should be updated regularly for even urine testing and what drugs they're testing for and when they're going to test, much less adding a whole new testing matrix.
Right.
And because drug testing falls under our Fourth Amendment, the employees must understand what to expect, and there must be a pre-employment agreement and notification. They must be very, very clear of what to expect so that this is fair for them. Now, if they choose to violate those rules, then we, consequences are consequences, but it's got to be in the policy. So we want to make sure that and this goes with collective bargaining agreements and all of those things. And one of the things that's so beautiful about this for you guys, you might think, what do I have to do with that? I don't talk to the business owners, I don't talk to the leaders, I just deal with the DER, right? But you are the trusted advisor, you're the expert for this company in these matters. So this gives you an opportunity of expertise to say, hey, have you thought about this? Have you done this? How can I help? And also, you might be sitting there thinking, I don't know how to help. That's why you're a part of a membership association. Because if you don't know how to help, but you're thinking, okay, Jill, what you're doing is sounding good, because listen, this is added revenue. You don't do a policy for free. You know it.
Right.
So, it sounds good, you don't know what to do, then you call your association. I used to do policies, not doing them anymore, but I will refer you to our expert members who do. So that you can find someone who can help you, and then you can offer that service and also learn a new thing that you can do for your employees for added revenue and diversification of your services. So let's go back real quickly. Every employer must have a standing order in place. Now I don't know how to redo the slides, but anyway. The last bullet was every employer must have a standing order in place before they can engage. Once we have the oral fluid test, once they can engage in oral fluid testing, the collector needs to know what to do and what type of test to run. So the question becomes, who makes the decision? right? So we're gonna see how effective our regional training has been over the last 2 years, okay?
Okay.
Pop quiz. Can the collector decide what type of test to do when the donor walks in?
No.
No.
Woo!
No.
Have we killed it? Let me tell you.
No.
Thank you, Odapsy, for a great presentation.
Okay, I wasn't here for Jennifer's speech, I'm sorry. But thank you for hearing that. The collector does not decide. Standing orders must be in place. So we will get to the standing order in just a moment, and I'll let you take the rest of this one.
Okay, so, let's see, you did go back a slide? Update any employer's policy that states urine is the only specimen authorized for testing. Okay, that's an easy start. And people said on town hall, hey, since we know that oral fluid's not in place yet, should we even bother to update these? Yeah, you should. And when you update them, you say, as soon as it's available, we will be using oral fluid for this. You know, we want to use it for this type of testing. If you notice, there's only one type of test, I tell you. I really think everybody should be doing oral fluid on. And other than that, I keep my mouth shut and I leave it up to you all as experts. But the one, please, once it's available, stop the direct observed urine collections. Let's just all agree to stop those once oral fluid is available. The update turnaround, we did it because we had to do it. We had to find some way to beat the cheaters. And we got taken to court on it. And many of you have heard the story. We won unanimously before the DC Circuit that said, Department of Transportation, this is what you need to do to address cheaters. But it may not always be that way. Once we have oral fluid, it's not going to be necessary anymore. So that's the one area I tell you, please, please, please make sure you guide your employers in their standing orders and you guide folks in your policies. But other than that, you do want to update it so that you take out the word urine as your sole method of testing. And you want to make sure that you say oral fluid, when it's available, is what we're going to choose for X, Y, and Z categories of testing. Let employees know the testing events for which an oral fluid test will occur. There's no harm in that. As a matter of fact, since they don't know how to study for the test yet, it might just actually help them make decisions for their life. And isn't this program about prevention anyway? So if they know they can't shoot an oral fluid test, then they just stop with the drug. So let employees know they do not have the option to choose what testing methodology will be used. And when it comes to the employer's policy, make sure you're following the requirements of the DOT agency regs. Because Federal Railroad Administration has different requirements for the policy than FAA, than FMCSA, and so on. So many people in this room are experts in various areas. That's why you're needed more than ever.
Thank you, Patrice. And you as the employer must choose the collection methodology and for which testing reason. We're going to show you a brief photo of the standing order. And then again, you, not the employee, for employers, choose the collection methodology for subsequent collection following a problem collection, right? So what we're talking about here is if you chose oral fluid and there's going to be a dry mouth situation, does the collector immediately proceed to a urine collection after we didn't capture a successful oral fluid, and vice versa for shy bladder? If we have a shy bladder, do you want the collector to stop the collection as soon as they didn't get the sufficient specimen and just go ahead and move to oral fluid? Or do you want to choose the 3-hour wait? But again, the collector can't be deciding. What the collector could do is call you. And then they could call you on the next person, and they could call you on the next person, and then they could call you on the next person. One of the very first presentations we gave was to the Federal Railroad Association. And
The American Short Line Railroad.
American Short Line Railroad, sorry. Not Federal Railroad Association, that is the name of the thing, sorry. Short Line Railroad. And I remember, I believe it was the very first one, I think, that we did. And Patrice stood up, and they were like mildly not so interested in this. I mean, they were just like, they were there, they were excited to hear us, but I think the very first question was how many of you have changed your policies, and I think we might have had 2 hands to prepare for oral fluid. And Patrice said, okay, so if you don't update your policies and you don't have a standing order in place, every collector will call you on every single collection to ask what kind of testing methodology they will use for every single employee who has a drug test. How many of you want that? And they were like, and that's really what actually should happen, is calling the employer and say, what am I doing? What am I doing? What am I doing? So we have worked very hard to work with industry to make sure that people hear this, get prepared in advance, the collector knows what to do, to include electronic chain of custody forms, so that in those systems, the standing orders are entered. We're grateful to the systems that have worked with us to prepare for that, so that that is placed in the drug test order right up front, so the collector's not guessing their way through it. But we also think that when it comes to the problem collections, that could be where it gets a little confusing and jumbled up, and then we're not really sure what to do.
Can I have a vanilla chocolate cone?
Well, I was just gonna say, you missed that, and if you don't do it in this very last presentation, I'm gonna be deeply disappointed.
Okay, good, thank you. All right, so today, when someone comes in for a DOT collection, we know they get a vanilla cone. There is no other choice. There's a vanilla cone. But when the first laboratories are approved, there's an option of a vanilla cone or a chocolate cone. You, the employer, are deciding that through your standing order. And if there's a problem collection, it might be a swirl. So, I'm big on analogies, sorry. But for some of you, that will help you understand why. So when we were up in front of these railroad executives, and I remember it was the very first session, they go, standing order, you shouldn't have chosen that term. Standing order means something very specific in the railroad industry. And I said, well, good for you, because standing order means something very specific in the Part 40 world. Standing order is about MROs leaving instructions for how they want things handled. And this is your opportunity to leave instructions. If you don't like the term standing order, you can call it employer direction, employer orders. You can call it Fred. Call it whatever you want. Just please put something in place so that the collector has some idea. Because who's paying for the test? The employer, exactly. So you should be the one as an employer to choose. And if you're a CTPA or other folks who work directly with employers, then help the employer choose, help guide them, provide your expertise. It's a great marketing opportunity, and DOT says you're welcome.
And we would be remiss if we didn't give a shout out to Colleen Weinhoff, who, when the rule came out, notice I said her name right that time, when the rule came out, Colleen was the very first one to raise her hand and say, I just read this through. I think you read it in the first 15 minutes, Colleen, like, please. But you read it through and emailed us and said, will you be providing a model standing order? And we looked at each other and went, why, yes, we will. And so we did, and we'll show that to you in just a moment. So changes also impacting employers as best business practice to have that standing order. And then otherwise, again, we said you'll need to speak with your collectors every single time. Do we think that's reality? We know what happens in reality. We understand that what should happen ideologically will probably not happen on the ground, but that is what is supposed to happen. So we do want you to know that. All right, you want to go ahead with the next one?
Sure. Until further word from ODAC, oral fluid testing must be performed for all direct observation collections for transgender and non-binary individuals once oral fluid testing is available. Okay, that's the way the rule reads today in 40.67. However, there has been a notice of proposed rulemaking pending for several months from ODAC proposing to extend that. Now, as of January 20th, the President put out an order regarding the removal of language regarding transgender. Okay, so that provision is likely to exit, but today it exists in 40.67. So again, I plead with you to just convert to oral fluid testing a direct observed urine collection for any employee. But that language is on its way out the door. People asked us, well, isn't that unfair? Is that just protection for transgender and non-binary people? Well, first of all, no, it's not unfair. Everybody gets a test result, and it is a legitimate test. But there are two people who are impacted in a transgender or non-binary collection. The individual who is being tested and the observer. The observer also has civil rights and should not be forced to observe someone. So again, this provision was made in order to try to take into consideration the civil rights of both individuals. So again, ditch the direct observed urine collection once you have oral fluid as an option.
Thank you. Okay, there will still be urine directly observed collections. Again, it will be the employer's choice. Again, what Patrice says, why would you choose that? Just because you can doesn't mean you should. All right, now, one of the changes to the rules that we had when this oral fluid rule came out, 2023, was that the collector's phone number, where they can be reached, must be printed on the change of custody form. That does not need to be your mobile phone number, but the MRO or the lab must be able to reach the collector. No 800 numbers, no call centers. This is in the rule. We just heard, was it last week or a week before, about a collection where there was a fatality that took place, and they were trying to, they needed to reach the collector because it was done on an ECCL form, trying to remember and the wet ink signature, the thing didn't work, they needed the wet ink signature to go forward on the case, and they could not reach the collector, and the DER was saying, I cannot get this test result. There was a fatality involved here. It's very important that we get this test result. The lab is held up, the MRO is held up. We have been trying for 3 days, and they actually said, I believe it was on DER Study Hall, may I walk into the collection site and get that? And we were like, yes, you can. Not all DERs can do that every time because most of their collectors are on the other side of the country. But this was a very important test. She said, can I call the lab and tell them how important it is? I said, oh, they know. They know this is important because every test is important. But they can't reach the collector either. They're trying as hard as you are. The MRO is trying as hard as you are. So collectors, we must be able to reach you. So that rule was changed for this very reason. And the calls were going to 800 numbers, and Patrice, as the director, was trying to test this out to see if it was accurate. And why don't you tell that story? We've got time.
Okay, I love this story. So, an MRO practice calls me, it's 2022, and they say, maybe late 2021, they say, hey, we have about 150 tests we need to cancel. Because we can't reach the collectors, and we can't get our MRO copy. And we just can't reach them, period, end of story. And I said, well, there must be some misunderstanding. So I contacted the company that had the call center. And I said, you know, this has happened. They said, that never happens. That is such a surprise. We'll take care of it. And they did. And then 2 months later, the MRO practice called again, and they said, we're going to cancel 200 now. And I go, why didn't you call the person I gave you? And they said, because they're not returning their calls. And I said, okay, I'll look into it. Give me 2 of the CCF numbers. And so, and give me copies of the CCF too. So I called the number that the MRO was trying to call. And I answered right away and said, please submit it via email and we'll get back to you. Okay, so I send it in, patrice.kelly@dot.gov, with my title and everything on it. I get an email back like this. We'll respond to you in 5 to 8 business days. 21 business days later, they got back to me. So I realized the problem was that employers, MROs, and DOT agency inspectors and auditors can't find the collectors via the telephone numbers. So we proposed the change and we made the change in Part 40. Overwhelmingly, the commenters favored that because this is what they were experiencing. And one recent story to kind of just nail this down, and I'll stop my stories on this slide after this, was that somebody had contacted us in Endesa, said, I had a situation where a collector reported something as a refusal, because the specimen was hot and the donor left before the 3 hours were up. And I said that those don't quite go together. Can you get me more information? And they said, no. We have tried and tried, our CTPA has tried, nope, we cannot get you any more information than that. And I said, okay, do you have enough information to make a decision? And they said, no, under 40.355I, footnote, because NJSA members are so well trained, you guys are awesome. They said under 40.355I, no, I can't, I don't have enough information. And I said, how long does the clearinghouse give you to report it? They said 3 days. I said, based on what you know, what's your decision? They said, no refusal. And they never got information to contradict that. So, the ending part of the story is that was not a refusal. Oh, and unfortunately, their CTPA later called them and said, you must enter it to the clearinghouse. And I said, just give them the email I sent you. And that took care of it. But again, 40.355, it's the employer's decision. If the employer can't reach the collector, end of story. If the MRO can't reach the collector, that's going to be the end of the story. If a DOT agency person can't reach the collector, that might really be the end of the story if you get my drift.
And let's be clear for those of you that are brand new, because we have so many people that are new here.
Yeah.
Those of you who've been in the business for a long time, you just read between the lines. Those of you who are new, what we're saying to you is, if that employer can't determine that's a refusal, and they let that driver go back to work, but that was a fake specimen and that person is using drugs, you just compromise safety.
Yeah.
Not the
Yeah.
traveling the traveling public. What was I saying? The safety of the traveling public. So take your job seriously and understand what type of safety professional you are, because those decisions not to give all the details could impact roadway safety. Just put a fine point on that. Okay, reminders applicable to current urine collections and controlled fluid collections. The preamble of the rule, which is just as important as what is inside of the rule, on every rule, reminds employers to ensure that the DERs and the phone number appear in step 1A of the CCF. We are seeing a lot of those where the TPA is pre-printed, that there's no information for the DER. That DER's information still must be accessible and available, and that is not new.
So if I could just point out too, it's been that way since the year 2000, which was the major rewrite into plain language of Part 40. There are very few people left at DOT who worked on that team. Patty's son, I want to acknowledge you, if you just wave to everybody. Patty worked on that role. I worked on that role with Patty, and Richard Wong, who's with the Federal Transit Administration. There are still experts in DOT who remember this, but you don't have to worry about that because it's in the preamble and it's been in the rule language. Okay, so important. That was not something we added in 2023. That's something that we added a long time ago. But people, for some odd reason, feel that the DER's number doesn't need to be there. And for those of you who are collectors, you have my empathy and my sympathy because that's awful. You can't reach anybody. Thanks.
Exactly. And so during Patrice's tenure, we covered a lot of trucking associations across the country. Not only did we work closely with national trucking associations, but we also have covered the state trucking associations quite extensively, primarily on the East Coast. But we did get the opportunity to also get up to Washington Trucking Association. And so in the room, we give them this presentation, and we get to this slide, and remind them, and it's the Trucking Association, so this is a room full of DERs. And I remind them that they must provide a list of qualified SAPs to both employees and applicants who failed or refused the drug test. And I thought we were all on the same page about that, and then the grumbling went through. I just saw like they were doing a wave. And this one lady raised her hand and she said, do you mean to tell us we have to give them a list of SAPs? And I said, yes, ma'am. And she said, that cannot be true. We just tell them to go find a SAP. And I said, absolutely
How
not.
did they know?
You must give them a list of, and you must make sure the SAP is currently practicing and that they can reach someone at the number you give them. This can't just be, and then, see, you know me, how I like explained it a little further.
It's true.
I must put this in my mouth because I said it can't just be a list of AA meetings. And then I thought we were gonna have an eruption because that's what they had been doing.
Oh my
They just
God.
been saying, here's a list of AA meetings in town, good luck.
Wow.
But we all have zero tolerance policies, we don't need a list of SAPs. We don't wanna make them.
Ew.
So this is so important to spread the word to your colleagues who may not understand that is a DER's responsibility, and it must be a current list of SAPs and listed some resources there for you.
Okay, so I'm ready for it. If anybody wants to challenge this again, Jennifer's pretty clear. Pre-employment refusals are different, right? We're talking about it's a walk away, somebody decided they just don't want to do a drug test. They haven't taken the cup yet, whatever, fine. That's a different category. But if they walk into the collection site and they punch somebody in the face, or if they say, I am not taking my coat off, or they engage in some other obstreperous behavior, you can call the employer and say, this was a refusal because, and give them all the documentation. I want you to carefully read 40.191. And you can go back to the preamble from the year 2000. We were very, or actually it's 2001, we added that in 2001, August. No, it's great, it's like all in here. So we added that because we wanted those unique situations protected. But when it comes to conduct at the collection site, that's totally different. You don't have to wait until you get the cup to declare a refusal if they are causing harm, they're doing something at the collection site that otherwise violates 40.191A, and go down the sections. The ones that have the pre-employment exception are clearly listed. The rest of them don't have that pre-employment. So again, think conduct, just like Jennifer said. Jennifer drew a beautiful dichotomy between the conduct and just walking away. I got another job where I don't, I'm a drug user and I decided I do not want this drug test. Okay, goodbye. That is what a pre-employment test is for. It's a threshold. If you choose not to cross that threshold, goodbye to you. And that's okay. You're not gonna get the job. So, problem solved.
All right, we're not gonna beat this one to death because we've got a whole couple of topics that we wanna get to, but remember that the DER determines the refusal. That is absolutely a non-delegable duty of the DER. And then every employer needs a standing order. We've talked about this, and I'm just gonna get to the example here. So this is just some screenshots of our model standing order that are on our website, available to you for free download. We give our members a lot of resources at no cost, and it's also in the drive of our oral fluid trainers, so that they can use it and co-brand it if they like. But it's literally a checkbox. What reasons would we do urine or oral fluid in a problem collection? Would we do urine or oral fluid? Would we continue with problem collections? And then you have the signature spaces, and we're official. So we really encourage, make this easy. Check, 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 update the tick box, and then good to go. So I'm actually going to let you introduce this first one, and then I'll ramble on about marijuana a little bit, because as you've heard, one of my favorite topics.
So, exactly this session, last year, at an ADASIS conference, I briefed about this rulemaking because my topic was going to be, how do you make changes to regulations? How do you do these things? And lo and behold, overnight, the Drug Enforcement Administration issued a notice of proposed rulemaking to reschedule marijuana. For those of you who remember, I was kind of a crazy lady. I got up at 3 in the morning to read that so I could brief you on it. And I used a lot of language from Hamilton. This year it was wicked, but that wasn't exactly where I thought you'd go with defying gravity. But last year it was Hamilton. If you don't stand for something, you'll fall for anything. And I really, really want to applaud Endesa, because I ghost wrote for them, which was totally allowable under my ethics provisions. I just couldn't interface with the government. But they allowed me to do a lot of ghost writing for them to explain what was going down. And that was if marijuana was moved from Schedule 1 to Schedule 3, it was going to fall out the bottom of the HHS process. Because there was an executive order by President Reagan that allowed HHS to certify laboratories for Schedule 1 and Schedule 2. And that's it. So the minute marijuana is rescheduled to Schedule 3, in my legal opinion, the bottom falls out. Many, many people realized that was correct. And in addition, Endesa filed comments that said, and the comments were Part 1, Part 2, and the request for hearing. Part 1 said, this will stop DOT regulated testing because HHS will no longer certify the laboratories and it will be over. That message through my sources got all the way to the White House, and I was told they heard you. They didn't realize that was what was going on. So it gave the administration pause. The National Transportation Safety Board picked up with Endesa's comments, actually included them on pages 6 to 7 of the NTSB comments. They didn't give us credit for it, but nonetheless, they did it. And the point was, it raised attention, it caused people to pause, and I'll turn the process over to you from now on this.
I just want to say that many of you know very clearly, because we heard it, that Secretary of Transportation Pete Buttigieg was testifying where they asked him when this happened, and he said, no, it won't happen. And so y'all started calling him. Well, Pete Buttigieg disagrees with you. Well, we knew that he didn't know. I knew he absolutely did not know about this. So our Governmental Affairs Committee got with the National Transportation, the Transportation and Infrastructure Committee.
Yes.
Under on the Hill. And they said, we don't believe the Secretary knows about this, and we'd like for you to educate him, so we'd like for you to ask him these questions. And we supplied the questions to him, and he answered them the way that we thought he would, and we said, see, he doesn't know. They knew the truth. Everyone else knew the truth. And I'm not dissing to Secretary Pete. We do not need to do that, but what we wanted to point out was there's so much misinformation out there this could happen, and even the DOT's own secretary does not understand the implications of this. And I want to applaud our Governmental Affairs Committee for being on it and finding a way to do that properly and appropriately. And there was never a big statement, there was no retraction or anything. Everyone just went, we can do something about that real quick. So that was amazing. That was absolutely amazing. So what we did, we started explaining to everyone, if this moves to Schedule 3, that means you can get a legal prescription for marijuana, legal valid prescription, and that means if someone is using marijuana and fails their drug test, and the MRO gets a legal valid prescription, which right now there's no such thing as a legal valid prescription in the United States. In medical marijuana states, it's just a registration card. No such thing as a legal valid prescription of a Schedule 1 drug, okay? So, but that would change with rescheduling, and you could have employees who then had a medical review officer turn that positive drug test result into a negative, and all you as the employer would know is everything's fine. So, not to mention the problem with testing for DOT. Many, many problems. So we were urging people to speak with their MROs because they would be put in a position of verifying and validating these, or choosing, we could choose to put a safety concern, which is what Dr. Todd Simmel recommended, but it would still put them in a very awkward position, and we kind of found this split down the MROs on who would do this and who would not. So it was leading to a lot of consternation and confusion. So ultimately, the urgency is now over because we were selected to testify based on our results. before the administrative law judge, but the cannabis industry sued. Now, I just read this week, everything happens the week of conference. We just read this week that a lower court has thrown out the lawsuit, but again, we're not really sure exactly what that means in this process, because the whole thing was started under the previous administration. Right. And we do not yet know where that leaves the DER and the DER, I must be tired.
The DEA.
The DEA and the DOJ in trying to figure out who's getting sued, because all of the people were from the last administration. So we think the issue is done. We think it was killed. We think we're on a good path right now, but that does not mean it won't come back up again. And it doesn't mean it won't come up even in this administration. We don't know. There's a huge amount of pressure on the feds by the cannabis industry. So ultimately, the problem is, how do you prove impairment? There's no impairment requirement. Now this is where we can get into a whole entire different presentation on reasonable suspicion testing. For cause is our greatest tool until we get better tools that are scientifically valid and accepted and evidentiary. It's my big thing. They've got to hold up in court. But under this change, also you need to understand, under this change, the feds said when they wrote this thing, HHS was pressured to do this, and the DEA was pressured by the DOJ. It was a big mess. It was a big political mess. But the proposal said, well, instead of the FDA overseeing this whole thing, if it becomes truly a medicine overnight, legislative medicine, isn't that what we all need? If that's what happens, then the state dispensary systems are handling this just fine. There's no reason for the FDA to step in. I can get medical marijuana in my town at the local gas station. Does that sound like a reliable system? So that was kind of terrifying. But anyway, this would leave the workplace in a huge quandary on how to handle these things. So,
and I'd just like to compliment Endesa for having the guts to stick it out at every point. And we were the only people who were selected for hearing who addressed the legality of this rulemaking, the actual Administrative Procedures Act. So Endesa had all bases covered. You had the guts to do this, and I want you to know the kind of voice you have with this organization. You were heard. You did not attack anybody. You were factual. You were direct. And as far as I'm concerned, you have my complete admiration. Drug testing, well, this is international conversations. So the drug and alcohol testing of FAA certificated repair stations located outside the US. Patrice Kelly Global Solutions, right? C80 Connections. A new regulation became effective January 17th of this year, and it requires repair stations overseas who actually go through the process of becoming certificated by the FAA to work on US registered aircraft. Okay, so not all foreign stations that do maintenance. These are 145 repair stations. They have to have drug testing in place for all personnel who perform maintenance on US certificated air carriers. Testing must be acceptable to the FAA. It should be Part 40 testing. And if you can't meet the requirements of Part 40 due to your local laws, then you need an exemption or a waiver. You will have to apply for those if you are one of these repair stations. And it impacts 977 repair stations across the globe. So it has to be consistent with your local laws, as I said, and implemented by no later than December 20th, 2027. Sounds like a long way off, it's not. FAA and ODAXI are each going to have to be considering the respective waivers and exemptions before somebody can operate, or they're going to be in violation of US law.
and I think y'all will be hearing a lot more about this in the years ahead.
Yes.
So again, we've talked about that we're engaging in conversations about safety policies worldwide. The workplace policy and the safety policy, which should always include, as Ruth mentioned, a recovery-friendly workplace outlook, is the hottest hot topic, and I cannot state this enough. Endesa became one of the first 12 companies in the United States certified, as a recovery-friendly workplace in 2024 through Global Recovery Initiatives. We are so proud of that designation. We got invited to the White House to sign a declaration. I heard from Kathy at our international meeting. We'll be going back to do it under the new administration because they want to make sure that everyone's on this page. But that's our conversation, is the safety policies of the workplace must include drug testing as part of the safety policy. So we are very proud to talk about that. More hot topics every week on Town Hall as they come to us, as you bring them to us. We continue to talk about them, to discuss them, and we're so excited that you're all here at our biggest Town Hall of the year, really. So thank you for that, and thank you to Patrice. I'm not going to look at you either. We're asking if you have any questions. Bring your questions to Town Hall. The QR code is for joining Town Hall. I'll leave it up here for just a moment, and my contact information is there. From this moment forward, really from a couple days ago forward, if you want to ask us questions, if you want to ask Patrice Kelly questions, you're going to have to go to...
We're going to have to go to Patrice Kelly Global Solutions, a subsidiary of Current Consulting Group.
I don't know why I double-mic'd her.
Okay.
I was kind of like Bob Barker there for a second. But thank you. It's been a joy. It's been a privilege. It's been a pleasure. It's been an honor. And I'm so excited to continue to do great work together.
And thank you all. It has been an honor and a privilege. You know, to a certain extent, these guys took a chance on me, right? Jim Greer, Joe McGuire, the board, and I think it's really been incredible, but I never want anyone in this room to forget that you are truly saving lives. You are transportation safety professionals. What you do is so important, and you matter. It's been my honor to serve you. Thank you.
All right, so while the chairman is coming, the current chairman, Jim Greer, is coming to the stage, we